Good afternoon and welcome to the Appellate Division, First Department. Most of you know how this goes. I'm going to call the calendar. You're going to tell me how much time you need, not the time that you want. Please understand that we are familiar with the record, your briefs, your case, sometimes more than you'd like us to be. And understand that the light is for you, not for this court. So if I see that my colleagues still have questions, notwithstanding the amount of time that I have given you, I will allow them to continue asking questions. So please don't fret when I cut your time short. People versus James Brown. 5 and 2 and 5. McMickle versus New York City Department of Education. Would you like to submit? Thank you. Geraldine versus, ladies, help me. How do you pronounce this name?
Guillaume.
Guillaume.
We don't know if the petitioner is here, or the appellant is here.
Okay. And you are for?
Or Ms. Baptista.
Okay. And you are here for? Okay. Would you like to be heard, or would you like to submit in light of the appellant's absence?
If the court has any questions, we're happy to answer them. Otherwise, likewise, Your Honor.
Okay, submission, thank you. People versus Manuel Rivera Santana. Submit. People versus Kevin Gamble.
Good afternoon. 4 and 1, please.
Respondent request 2, please.
4 and 1 and 2. Shabtai versus HFZ Capital.
On behalf of appellant, Your Honor, we request 6 and 1.
Okay. 6 and 1 and 4. Garcia versus 122-130 East 23rd Street. 5 and 2. 5. Febres versus MTA. Thank you. Goldberg versus Torum. Wait until the calendar is called. Okay. All right. Respondent is not here. Do you wish to submit? 2 minutes and 0 on Torum. People v. Raheen Jackson.
5 and 2, please.
Okay.
4, please.
5 and 2 and 4. LaShawn K. versus Amanda T.
Here for the respondent, Mr. M. Request 5 minutes.
Okay. Anyone?
5 minutes for the child, Your Honor.
For the child? Anyone here for appellant? Okay. Beller versus Tao. Okay. 7 and 2 and 7. Jewish Press versus New York City Police Department. Submit. People versus Xavier Stocks. Submit. Caldwell versus 4 NYP Ventures.
Me too. Respondent appellant, Respondent for NYP 6.
Okay. ABM 5 and 1, plaintiff 5 and 2, NYP 6. Velasquez versus 94 East 208th Street Partners.
Respondent, 94 East.
Would you like submit? Thank you. Please have a seat until the call of the calendar. People versus Angel Diaz.
5 and 1, please, Your Honor.
Okay. You asked for 5, so I'll give you 4 and 1. 4 and 1 and 4. People versus Kadir. Submit. That's 2 cases. Countrywide Insurance versus Bay Needle Acupuncture is submitted. Benavides versus New York City Health and Hospital Corporation is submitted. First case on the calendar, People versus James Brown. You may proceed.
Thank you. Good afternoon. Rebecca Besden with the Office of the Appellate Defender for James Brown. The trial court erred by, once again, issuing a cursory denial of Mr. Brown's speedy trial motion following remittal by the Court of Appeals. There are two adjournments in dispute here. Either would put the prosecution over their speedy trial limit. I would like to focus on the September 27th adjournment. Now, the remittal court's only justification for excluding this adjournment was a purported defense concession. But the problem is that the language quoted actually came from the prosecution's motion papers. Respondent concedes this mistake by the remittal court. Other than this mistaken...
So what was the defendant's response with regard to that particular adjournment on the original 3030 motion?
On the first round of motion practice, the defense did not address that adjournment in the reply papers.
So why is that not waived?
Because upon remittal...
Didn't the defense have to establish that they had already articulated an argument why that particular adjournment was excludable time in the previous motion papers in order to preserve that issue for this second go-round on remittal by the Court of Appeals?
Well, upon remittal, the remittal court ruled that the parties would be permitted to take different positions than they did prior to remittal. So the court said that there would be a de novo round of motion practice and the issue would be newly briefed. The prosecution did not object to that ruling that this would be a de novo round of motion practice.
Okay.
And so any objection by the prosecution is waived and it's also precluded by the LaFontaine rule. But regardless, this was an entirely proper ruling and it's well established that following appeal, the court has discretion to allow new arguments that were not made prior to appeal.
Okay, so tell me, what is the argument why that time should be excluded now?
The reason that the time should be excluded now is that the prosecution utterly failed to meet their burden to ensure that the record was sufficient to establish the reason for the adjournment. This obligation that the prosecution has, this primary burden to provide the reason for the adjournment on the record is very well established. These facts are particularly similar to People v. Brewer, where this court held that, that an adjournment should be charged to the prosecution where neither party appeared because the prosecution failed to meet its burden of ensuring that the record contained the basis of the adjournment. Similarly here, the prosecution did not ensure that the record contained the reason for the adjournment.
What did the record say?
The record said that neither party was present, and then the court said this has already been adjourned, and that was the entirety of the record. So the prosecution did not even come to court, let alone...
Well, neither side came to court.
Yes, but that was the case in Brewer as well, and the time was charged to the prosecution because the prosecution has the primary burden of establishing that the record is sufficiently clear.
What was the adjourn date prior to that September date?
That was, no, that was...
Sometime in August?
15th? It's possible.
What was said on that date?
Well, this was a post-readiness adjournment, if that's what the court is getting at. There had been a prior statement of readiness, but again, in Brewer and in additional cases in the Court of Appeals case Jameson, the courts have held that even in a post-readiness posture, the prosecution retains this obligation to ensure that the basis of the adjournment is clarified on the record. And because the prosecution didn't come to court, they have never provided a reason for this failure to come to court. The prosecution failed to meet this burden. And I think it's telling that respondent has made arguments which are meritless that this claim was waived, but has not made any arguments based on the record that this adjournment should be charged, should be excluded. And that's because the record is very clear that the prosecution failed to meet that burden.
Okay.
If there are no further questions, I'll reserve further time for rebuttal.
Okay, thank you. You may proceed.
Your Honors, and may it please the Court, Anna Notchik for the people. Just to clarify, the disputed time period is November 27th to January 22nd. The time period,
I need you to enlighten, are you contesting counsel's statement that the Court of Appeals remittal permitted new arguments on any adjourned date that either counsel wanted? Are you contesting that?
Yes, Your Honor. The remittal was for the specific purpose of to hold a hearing on
The question is whether the remittal specifically said that any new arguments could be proffered. That was my question to you.
The remittal specifically said that if necessary, hold a hearing to determine the excludability of the other disputed time periods that the courts below did not address. We would argue that this time period from November 22nd to January 27th was never considered by the courts below. They had
I
not
thought I heard
addressed
her say September. Did I misread? Oh, you made a mistake. Okay, I'm sorry. Go ahead.
No problem. So as to the November 27th adjournment, defendant has previously conceded that this adjournment should not be charged to the people. In the 2008 motion papers, defense counsel, who was the attorney at the time, evidently had more knowledge of the reason for the adjournment. Defense counsel specifically said that the days chargeable for this adjournment for either indictment were 0. The people were allowed to rely on that concession moving forward. Defendant never disputed the people's assertion that defendant had requested the adjournment until the second round of motion papers in 2017 in reply. That concession also supports the substantive determination that this adjournment was either on consent or with defense or at defendant's
The
request.
problem you have is that the record is bare, right? Because no one appeared in the part. The clerk did not state the reason for the adjournment. So it seems to me, based on the remittal and the language in the remittal, that this particular adjournment is up for grabs and up for new argument.
Well, the people had always relied on the defendant's concession.
That's fine, but the Court of Appeals said they could articulate new arguments. So now deal with the substance of the argument.
We would say that the substance is that defendant either requested or consented to the adjournment because neither party appeared in court.
How do we know that when there's no record?
Well-
You're saying it must be a consent because nobody appeared, but the people didn't appear either.
Well-
So why should I speculate as to the reasons why? I have nothing on the record.
What we have in the appellate record on appeal is defendant's prior concession that this was excludable. That concession supports the determination that neither party appeared in court because
So if we have no concession and the Court of Appeals said that we can reconsider, what is your response to the adjournment?
well, Your Honor, again,
You can't just stick your head in the sand and say, they said they said there was no issue. If the Court of Appeals says they can relitigate it, then I need a substantive response from you.
Well, Your Honor, to clarify, we don't believe that the Court of Appeals intended for new arguments to be made. The court said to have a hearing, if necessary, to determine the excludability of the other disputed time periods that the courts below did not address. The courts below had not addressed this because defendant had never conceded it. So
your argument is that because it had been addressed and they conceded it, this cannot be part of the court's reconsideration.
that, yes, Your Honor. And as to if Your Honors have any questions regarding the first adjournment from April 16th until May 30th, I would be happy to answer. But otherwise,
Yeah, there were two specific periods that it seemed to me that the defendants relied on. One was the one you just mentioned, April 16th to May 30th, and the second, which we just discussed. So why don't you just briefly touch the April to May?
As to the April 16th to May 30th adjournment, that time period is clearly excludable as motion practice. On April 16th, the people stated that they intended to file a consolidation motion. The defense stated they intended to oppose that motion and file an omnibus motion on the second indictment. Then on May 9th, the defense requested additional time to respond to the people's motion. That clearly makes the entirety of the 44-day adjournment excludable as motion practice.
Okay,
If there are no questions, we ask that you affirm. Thank you.
thank you so much. Okay, you have 2 minutes.
Thank you. Just to briefly touch on some areas raised by the respondent, I think it's important to stress that the prosecution never vocalized an objection when the court following remittal explicitly said that the issue would be briefed de novo and that parties would be taking positions
Are
different.
are you taking exception to your adversary's statement that what the Court of Appeals said was that those adjournments that had not been ruled upon are sent back for reconsideration, and this particular adjournment that you were referring to, the November adjournment, was essentially ruled upon because it had been conceded?
Well, it's certainly a fair reading of the remittal order that a hearing was required and that there were additional adjournments, that any additional adjournments which were disputed would have to be dealt with as well, and that includes any adjournments in dispute. Following remittal, the trial court explicitly said that the parties would be permitted to take different positions than they took during the initial round of motion practice. At that time, the prosecution did not object. Any objection to that decision by the trial court following remittal, again, is unpreserved, and any review of it would violate the LaFontaine rule, but this was an entirely appropriate ruling by the trial court following remittal because it's well within a trial court's discretion to open up arguments to arguments that had not previously been made in the context of suppression, the context of SORA hearings following remittal. So the prosecution did not object to that argument. It is unpreserved, and it was an entirely proper ruling by the trial court. I just also want to stress that the fact that respondent offers alternating explanations saying that either the adjournment was requested or it was consented to just underscores how much speculation is happening here, how much guesswork, and a motion cannot be granted without, or cannot be denied without a hearing without unquestionable documentary proof. And guesswork is not unquestionable documentary proof.
Okay,
So if there are
thank
no
you so much.
further questions, we'd ask the indictment be dismissed. Thank you.
Thank you. People versus Kevin Gamble. You may proceed.
Good afternoon, Your Honors. My name is Ivan Pantoja, and I represent Mr. Gamble. We respectfully request that this court exercise its broad plenary power and reduce Mr. Gamble's sentence from 5 years probation to 3 years probation for the following reasons. First, this was Mr. Gamble's first criminal conviction. He did have
Yes, but
prior-
it's not his first run-in with the law. And he has had the benefit of both JO adjudications and YO adjudications granting him probation several times. And yet he continues to find himself in front of the criminal justice system. So why is not 5 years probation for carrying a defaced, loaded firearm a more than fair sentence?
Yes, Judge, I do understand that he received a prior JD and that he did receive a prior youthful offender adjudication for a misdemeanor. But it is still his first criminal conviction. I think one of the things that the plea court really considered, as well as the DA, in acknowledging that a sentence of probation is the adequate sentence, was Mr. Gamble's strong employment history. He had been gainfully employed for a significant amount of time.
But being on probation won't interfere with his continuing to be employed and may also keep him under supervision, which might prevent him from getting in trouble again.
Yes, Judge, I don't know if that's been conclusively proven. I do know that some individuals on probation do encounter difficulties in navigating the requirements of probation and their employment.
But he's not one of them. He has navigated probation twice, right? It hasn't prevented him from getting in trouble again, but he has been able to absolutely navigate probation.
Yes, and I think that speaks to his strong commitment to work. It is challenging at times to have a full-time job and have additional responsibilities. That could include probation and other life circumstances.
Well,
And I-
counsel, in light of the fact that we now have the Less is More Act, if your client stayed within the confines of lawful behavior and did everything he was supposed to do, wouldn't the term of probation be reduced?
No, Your Honor. The Less is More Act specifically addresses those who are on parole or post-release supervision. And there's additional components to that law, but they do not serve to reduce the period of one's probation.
Yes, but probation has repeatedly reduce somebody's probationary sentence where they are fully compliant. They will reduce the amount of the intermittent reporting, et cetera. There's all kinds of ways that probation officers can award probationers who are following the rules and doing very well on probation.
I just want to follow up, if I may, Justice
Yes, of
Manzarek.
course.
But so going back to that, I mean, back to the Less is More Act, certainly if there's a technical violation, he would no longer be subject to incarceration if he did what he was supposed to do, right?
Correct, Your Honor. And I do acknowledge that, yes, probation in certain circumstances will agree to go with the client to court and request that the probationary term be reduced. Similarly, Your Honors, and this court have reduced also periods of probation in similar circumstances. Your Honors and this court have often reduced periods of probation from 5 years to 4 and sometimes to 3. And this is
counsel, this is Judge Gonzalez. With respect to the 5 years probation, hasn't the defendant already served 4?
He has served.
How much remains outstanding?
He has very little left in terms of probation. So this, in effect, is a very moderate or a very small request on behalf of Mr. Gamble to reduce his probation, actually, but just by months. So this is not.
How many months exactly?
I believe he may have 2 or 3 months left. He was sentenced.
The decision may not even be published in time for it to make a difference.
Your Honor, I think hope springs eternal, and I think I trust Your Honors would consider this efficiently and perhaps decide in Mr. Gamble's favor.
I thank you. All right, counsel.
May it please the court, Oliver Lee for the District Attorney's Office. Your Honors, the waiver here is valid. This court doesn't even need to consider defendant's excessive sentence claim. However, even considering the merits, defendant's sentence is exceedingly fair. He received probation rather than the mandatory incarceration that he faced. Additionally, Your Honor, the penological purpose that is served by defendant completing his full probationary term is deterrence. Defendant received an aggravated driving while intoxicated conviction while on probation for this case, meaning that he pled guilty to driving while his blood alcohol level was more than double the legal limit. Your Honors, if there's no further question, I would ask that this court affirm, and I would rest on my brief.
Thank you.
Just briefly, Your Honor, the waiver of appeal here is clearly invalid. The oral colloquy was clearly deficient. There was a written waiver that perhaps was adequate, but the written waiver was signed well before the oral colloquy. So anyone in Mr. Gamble's position, taking what the judge was saying, would probably acknowledge that that's what the waiver of appeal means. And what the judge did in this case was say that basically, by you signing this document, you're waiving all appellate rights. No court of appeals, or this court, has acknowledged that a waiver of appeal can cure a clearly deficient oral colloquy. And second, in regard to the point regarding the new crime and new arrest, it is absolutely troubling, but probation has sought not to violate him for that arrest and conviction. I requested an updated rap sheet from the district attorney's office to confirm that, and they in fact have confirmed that he has not violated probation as a result of that unfortunate incident. If there are no further questions, I'd ask that his probation be reduced.
I'd be careful about what I ask for if I were you.
Yes, Your Honor.
Okay?
Have a great day.
Thank you. Have a good day. Shabati versus HFZ Capital, and if I'm mangling the name, forgive me. You may proceed, sir.
Thank you. It's Shabtai, I believe.
Shabtai, thank you.
This is an appeal from a default judgment by the court below based on factual and legal theories not found in the complaint or anywhere in the briefing below. The standard to vacate...
Well, that's not the issue, though, right? The issue is whether the court entered a proper default judgment. So why don't you focus there, because that's where we're focused.
Okay. So two prongs to the default judgment, a potentially meritorious defense and reasonable excuse for
And
not
what
answering.
is the reasonable excuse? I read the record very carefully, and I couldn't find any reasonable excuse. Perhaps you could help me out there.
So we start with the Court of Appeals decision in the Di Lorenzo case, which says there's no per se rule where failing to update your address with the
Oh, we have, this department has so held many times.
it's so held the other way many times too is the problem. We have, by my count,
But it's not an abuse of discretion for the court to find that it's not a reasonable excuse.
so that
And that's the standard, isn't it, counsel?
And what was the reasonable excuse offered here? Because like she said, I didn't see one.
So I'll take this question first. The standard here is abuse of discretion, but this court can substitute its discretion for the court below.
Right, but we generally don't do that if the motion court hasn't abused its discretion.
And-
We generally give a lot of deference to the motion court. Why should we do differently here?
I would suggest it's appropriate here because you have no willfulness in the record.
Well, wait a minute. They said it wasn't their priority. Isn't that willfulness? They said, oh yeah, we know we should do that, but it's not our priority, so we're not bothering. That sounds to me like willfulness.
In the record, there was an admission that it wasn't done. Nobody was, and to clarify the
No, but
declarations that were
it went
filed.
beyond, we didn't do it. What your employee said was, that wasn't a priority for us, so we weren't paying attention to that.
I think, but there's a difference
Quote, it
between.
wasn't a priority.
There's a difference between understanding you have to do something and not doing it, which is not what happened here, and effectively.
If I can go
catching-
further with that, Justice Daniels, because it wasn't a priority because the employees were working from home. And also Monroe and I believe Woodcoff expected that HFZ would forward any important notices. That's on page 124, 125 of the record, right?
Yes, Your Honor.
Okay.
And
And now, the new excuse is, I believe it was inadvertently, what was it? It was inadvertent, the failure was inadvertent. So which one is it? Inadvertent or it wasn't a high priority because of everything that I said that's on pages 124, 125 of the record?
it was inadvertent, and what the focus was effectively catching a falling knife. This was a hotel that was vacant. There were vagrants squatting in the hotel.
This was a hotel that your clients accepted money to convert the hotel into a luxury condominium. And then somewhere in the midst, and it may have been a perfectly legitimate business decision, but they make a decision not to move forward with the hotel and, oh, by the way, not tell this investor.
No, that happened before we got in. We were a lender to HFZ. We took control of this property in 2021. The decision not to go forward with the investment happened in 2017. Our clients lent HFZ over $100 million. They were not repaid. They sued HFZ. Ultimately, there was a settlement. As part of that settlement, this property, the entities controlling this property were conveyed to my client. At that point in time, they had a hotel that wasn't open. There were squatters in the hotel. They hadn't paid their
But
taxes.
that has nothing to do with why they didn't change their address with the Secretary of State.
That was the initial focus. There was a question about what were you doing if you weren't updating your address? They were focused on saving this property. They did update the address before getting notice of the default. At the time of the default, nothing had happened in the litigation. There had not been a notice, an RJI filed. There'd been no
It
discovery
doesn't have to be
taken.
that if your client.
So
defaulted.
counsel, if I may, was the change of address effectuated before the defendant canceled the articles of incorporation in Delaware?
Um,
The the cancellation occurred in September of 2021 and again in October of 2021. So was the cancellation a priority as opposed to having a mailing address for service of process?
The address was updated in October as well, Your Honor. So that was all happening at the same time. And there was, I was going to say, there was no willfulness here and no prejudice. At that point in time, there had been no litigation that had occurred, literally none. And the first act in this case was taking this default. We then immediately, upon learning of the lawsuit, stepped
Once
in
it became a priority for your client, you stepped in, but you didn't bother to deal with your obligations until you decided it was a priority, right?
No,
Until your client decided it was a
No,
priority.
until our client had knowledge of the lawsuit. That was, once we realized, my God, we did not have notice of the complaint. My God, a complaint has been served. We didn't receive it. We retained counsel, and we were in court within a week on this, or
Justice
making
President.
contact with them in a week.
I just have one last question.
Go ahead.
Because you had mentioned earlier case law, but how do we deal with our precedent just from last year, which was cited in respondent's brief? You know, the Mahata case, that failure to maintain a current mailing address for service of process with the Secretary of State that does not constitute a reasonable excuse for defaulting. So can you address that case? Because that was just from last year.
Yeah, so DiLorenzo said that case relied on failure to update, but also the length of the delay they considered, the willfulness, and the prejudice to the other litigant. And that's what DiLorenzo says you have to. DiLorenzo has said there's no per se rule, so it can't mean that that decision establishes a per se rule. So then you're analyzing all the facts. You're analyzing prejudice, delay, and willfulness, and that's why I've been focusing on those factors.
Thank you.
Thank you, Your
We'll
Honor.
have time on rebuttal.
Ethan Cobry of Schwartz, Sladkus, Reach, Greenberg, Atlas. Good afternoon, and may it please the court.
So was your client prejudiced by the delay in their,
The answer is yes. Number one, I understand that litigation costs may not necessarily be prejudice, but here we're dealing with a bunch of overlapping entities that are essentially alter egos of one another. There's no question about that. That's not disputed. The problem is that my client has had his capital investment, his put option, stolen out from under him amongst this confusion between all of these related entities that are essentially alter egos of one another. And now, whereas we would have been able to litigate this issue, now we're left holding nothing, and we have to chase essentially through various layers of these alter egos. We're never going to be able to find that. So absolutely, my client has been prejudiced. And frankly, I don't even think that this court ever reaches prejudice. George Washington once said, it's better to offer no excuse than a bad excuse. And here, appellants have done even worse. They've offered not just one bad excuse, they've offered a bunch of bad excuses that frankly, as your honors point out, they contradict one another. So first, they say they neglected to update their address due to the demands of managing the property. Then they say some employees were working from home. Then they say they expected, as Justice Kennedy pointed out, they expected HFZ to forward important notices to them. Remember, HFZ is the party that they essentially just displaced from ownership of the property. How could you possibly expect HFZ to forward important notices? They were at odds with HFZ. Then they said it wasn't a high priority. I'm sorry, you need to make it a high priority. That's what the law requires. That's what this court requires as recently as last year in the Mahata case, as Justice Kennedy pointed out. Now they're saying in their appellate brief that it was inadvertent. The bottom line is they failed to update their address for about a year, and this court holds time and again that where a defendant doesn't receive service of process because it failed to keep its addresses current, the courts will not find a reasonable excuse. And so I do believe, Justice Gesmer, that my client has been prejudiced. Frankly, I don't think that we ever even get there. And that's why we don't even get to whether or not they've established meritorious defenses, because As this court pointed out in the Rudd Mechanical versus ZDG case that we've cited, Justice Kennedy, I believe you were on the panel in that one, and as is well known, you never reach meritorious defenses if the excuses are, as George Washington said, pretty bad. I just wanted to address very briefly, and then I'll sit, the line, I wouldn't even call it a line of cases, but the one case that they cite for the proposition that this court can superimpose its discretion for that of the trial court. That was a 1991 case from this court, Ackerson, and it's important to understand the facts there. That was not a case where the defendant defaulted in appearing. That was a case where the defendant appeared, and then because an associate left the defendant's law firm, there were a few discovery deadlines that were missed, where this court said, we're going to step in and we're going to say, you know, in our exercise of discretion, that we're going to overlook the default. This is a far, far cry from that old case. Thank you.
Thank you.
Just briefly, on prejudice, they're litigating against HFZ right now in the court below. So a remand here puts us right back into the case. They're litigating, continuing to litigate against HFZ, these very claims, this case. On the idea of chasing money, we bonded over this appeal. We've done everything right to the extent that we are not successful in appealing. They will get the full amount of money they're entitled to. Incidentally, they asked for $3.5 million. The court gave them a default of $4.5 million. I don't understand that. And the length of the default here, 5 months, not 1 year. To go back to the Mahata case from 2022, there was no excuse offered in that case.
You could consider it wasn't a priority, not much of an excuse either.
I don't.
I'm not sure that's really a good distinction, counsel.
I don't. Not a priority, I think, has been taken out of context, and I do think it's unfair for someone that's trying to save a property and the jobs and the people that work in that hotel where it's closed in the middle of COVID. I think that one's business focus there is an appropriate thing. To the extent somebody said it was not a priority, I don't think that's a fair assessment. They did update this before they learned of this default, so it wasn't the address. So it wasn't like somebody was saying, okay, we're caught, let me get out of it. They just were too slow.
Thank you.
Thank you.
Garcia versus 122-130 East 23rd Street.
May it please the court, John Shaw for plaintiff appellant. In a nutshell, the lower court order respectfully should be reversed. First, in its decision, the lower court said that plaintiff's failure to obtain a corroborative affidavit from Julian Sabato was...
Is there any evidence proffered by defendants here that is not hearsay?
Negative, no, Your Honor. Their entire defense and opposition is based completely on hearsay and is based on an alleged unsworn and unsigned affidavit of Julian Sabato. We don't even know who prepared this alleged unsigned affidavit.
In fact, there's little basis for calling it an affidavit since it's neither signed nor sworn to. So there's not actually an affidavit in front of us.
Correct, Your Honor. There's no affidavit. There's not even in some cases, as this court knows, they'll obtain a statement, say, from the Workers' Compensation Board, which we relied on in the Maldonado case. But in Maldonado, first of all, it was from the Workers' Compensation record, and it was signed, and the court noted that there was other evidence besides that. And the other case they rely on in Chianese, there was a transcript from the investigator who obtained statements from a witness who later on they obtained an affidavit that was contradictory. And in addition to that, there was an affidavit from the plaintiff, which was sworn testimony, totally distinguishable from this case. In this case, you have a piece of paper, and then you have evidence of, or an attempted evidence to somehow cherry pick that affidavit from these two so-called investigators that said we attempted to obtain an affidavit, and there's nothing there. The affidavit of these investigators is legally worthless as a matter of law. One of them said, I spoke to Mr. Sabato in July, and we don't even know if he's the one who prepared the affidavit. And then 3 months later, we get another affidavit from another investigator saying, I obtained some information, and I couldn't obtain his address, but I spoke to him the next day, and I had a few contacts with him, and then they drop off the planet. So putting aside...
So counsel, in your view, there's nothing to establish that the plaintiff was a recalcitrant worker, is that right?
Correct, Justice Gonzalez. There's nothing. And unless this panel has any other questions, I'll rely on my brief.
Thank you.
Thank you.
May it please the court, John Fabiani for the respondents in this case. First of all, I think we're putting the cart before the horse because the Supreme Court did not deny the motion based upon the papers submitted in opposition.
Well, let's say
Go ahead, Judge.
let's say we disagree with the court below and think that the plaintiff absolutely made a prima facie case. And so it then goes to your clients to controvert that. How did they?
How did they? Well, first of all, there were two affidavits from witnesses with personal knowledge, including Mr. Endalali, who testified.
But they had personal knowledge of what? Of having a conversation with someone else?
No, Mr. Lally had personal knowledge that there were component parts of two separate
No one disputes that. The question is whether or not the worker was instructed by Mr. Sabato to use them anyway.
And Mr. Lally
did
wasn't
not have knowledge about that.
Justice Gesman, that is exactly why Judge Sattler denied the motion.
Well, I don't know. That's actually, well, that's not what her decision said.
Because she held that he did not establish that he was not the sole proximate cause of the accident because he knew.
Okay, let's back up a second. As Justice Manson-Daniels said, let's assume that we found his statement sufficiently compelling that he was told by Mr. Sabato, use these whether they fit together or not, do what you can.
Mm-hmm.
That's what we have, and suppose that we find that established his prima facie case. I don't see how any of your affidavits refute that in any meaningful way.
Well, Mr. Lally's affidavit, which was based upon personal knowledge, is that there were there were component parts of two separate scaffolds, that two separate scaffolds were to be built.
Right, and
the plaintiff knew that the parts that he had.
Plaintiff knew that, and he said he was told anyway to use them by Mr. Sabato. So the affidavit that you're saying refutes it is not at all inconsistent with his affidavit. He knew that they were incompatible.
Well, he's relying on...
And in his affidavit said that Mr. Sabato told him, too bad, use them.
Hearsay. So it's
No,
hearsay.
it's not hearsay. It's a verbal,
hearsay.
of course not. It's a verbal act by his supervisor directing him to act. That is not hearsay. It's not offered for its truth. It is a verbal act by his supervisor to him.
Offered to justify the fact that he put together a scaffold that didn't work, knowing that the scaffold was not going to work.
That doesn't make it hearsay, counsel. It is not hearsay. It's not offered for its truth. It is offered for the fact that his supervisor said that to him, and therefore it's a verbal act, not hearsay.
Okay, so then you want to address whether the affidavits that were submitted by the defendants refuted his prima facie showing that he was given two incompatible parts that he voluntarily chose to put together. Mr. Lally testified that there were two scaffolds. Now we turn to the issue of Mr. Sabato and the affidavit. This case is on all fours with the Chinese case. The Chinese case was my case. I obtained summary judgment in Supreme Court. Judge Lowe granted me summary judgment. The only opposition that was put into that was a transcript prepared by an investigator of a telephone call he allegedly had with the perpetrator that contradicted the affidavit the sworn affidavit that my investigator had obtained from the perpetrator. That was the only evidence in opposition to the motion. The evidence of the evidence that Mr. Shaw referred to of the plaintiff's testimony in that case had nothing to do with the issue that was before the court. That was of how the perpetrator obtained access to the building. So and the court in Chianese wrote that hearsay may be heard to defeat a motion for summary judgment.
So long as it's not the only evidence.
That's correct, and it's not the only evidence.
And I don't see. Look, the fact that Lally says, when I got to the scene after the accident, I saw parts on the floor, tells me nothing.
Well, it tells you that it confirms.
It tells me that the scaffold that the plaintiff was on fell.
No, it tells you that
Okay.
It tells you that there were two separate scaffold
I
parts
don't know
were
that.
used. But that's what Mr. Lally said, and Mr. Brennan supported, also found.
How do we get past? Because really, the real issue is whether this plaintiff ignored the direction of Sabato and used a scaffold he was told not to use. That's the issue.
Well,
And the only evidence you have in contravention of that issue is all hearsay.
No, we have the issue. We have the evidence that the plaintiff knew that the scaffold that he was constructing was composed of parts
And
that were
if his supervisor
incompatible.
told him to get on it anyway, that would not make him a recalcitrant worker.
Thank you, Judge, because that's exactly what Judge Sattler latched upon. He had nothing from his supervisor, no supporting evidence from his supervisor.
It sounds like he shifted the burden to the plaintiff.
No.
And it was the plaintiff who made their prima facie case. It was incumbent upon the defendant to offer non-hearsay evidence to controvert it. And I don't see any.
He admitted that he knew that the parts were incompatible, yet he tried to put them together.
Because his supervisor told him to. And that's...
Why is that not a question of fact? Why is his
excuse
credibility
me,
not an
excuse
issue?
me, the reason it's not a question of fact is that you didn't put in anything which controverted that Mr. Sabato told him to use it anyway. All you put in was an unsworn statement, which I would not dignify by calling it an affidavit, and hearsay. So none of that contradicted his statement that Mr. Sabato told him to do that.
Okay, your time is up. We got your argument. We got your argument. Trust me, Mr. Fabiani. We got your argument. You have time. We may not agree with it, but I got your argument.
There's really not much more for me to say. We established our prima
Smart
facie
man.
case.
Have a
and
good
I'll rest
day.
of my brief. Have a good day.
Have a good day, both of you. Likewise. All right. Goldberg versus Torum. You have 2 minutes.
Thank you, Your Honor. May it please the court. Good afternoon. My name is Michael Urshowski for the appellant Leotorim. My client's husband, the appellant's husband, had some sort of agreement with the plaintiff as to this real estate investment.
We know the facts.
Yes, Your Honor.
My concern here is that we are being asked to believe that your client had no idea what her husband was doing and that she signed and forged a signature on a real estate transaction completely unaware.
Well, Your Honor, it's the plaintiff's burden to show knowledge and to at least allege knowledge. Frankly, the allegations that have anything to do with fraud have have really nothing to do.
We're only at the motion to dismiss stage, so we have to assume that the pleadings we have to give weight to the pleadings. And they allege that she forged a signature. So why should we excuse that?
Your Honor, the plaintiff does not allege that he was harmed by a forgery, and he doesn't allege that. he simply states that he actually states in the briefing and in the pleadings that he wanted Mr. Turim, the defendant, to take actions on his behalf.
Well, but he certainly states that he was harmed by not knowing that the property was sold for $700,000.
No, he states that he was harmed because he didn't receive the balance of the $700,000, which has nothing to do with anything having with any fraud or any. And frankly, the fraud allegations have all been dismissed.
I'm sorry, he was lied to about the amount of money that the property was actually sold for, correct?
No, Your Honor.
No? He was told the real amount?
Yes, Your Honor. He was told it was sold for $700,000.
Contemporaneously or much later?
Well, at the time of the sale. Your Honor, there was no time in, but the property was sold in July of 2017. The allegations that he did not receive the money were in August of 2017. He received $525,000. He claims he should have received the entire sale price. That's the dispute. The dispute is not whether he was tricked into something. The dispute is whether a purported fiduciary delivered the full profit and what the contours of that agency agreement were. My client never had any contact with the plaintiff whatsoever at any time. He does not claim that he was somehow defrauded by her. He could not even amend his complaint to allege a case of fraud against her. It was simply that she, through an entity that he alleges she only nominally owned, did not deliver a check that she had, from his own account, no reason to believe that she was supposed to deliver any funds to him. It was only acting through the defendant, Mr. Turim. He has zero allegations that have anything to do with my client, and frankly, the precedent that we put forth in the briefing deals with all of those issues.
Thank you.
Thank you, Your Honors.
People versus Raheem Jackson. You may proceed.
Thank you. Good afternoon, Your Honors, and may it please the Court. I'm Stephanie Sonsino on behalf of Mr. Raheem Jackson with the Office of the Appellate Defender. There is no credible evidence that Officer Nunez saw a gun before he searched Mr. Jackson's
Before
car.
we get to the underlying substance of the suppression issue, do we even get there in light of a plea of guilty and the waiver of right to appeal? If we find that that waiver was appropriate and valid, your appeal to the suppression falls, no?
Yes, Your Honor, but the appeal waiver here was absolutely invalid. The trial court has a responsibility to ensure on the record that the defendant, Mr. Jackson here, understands the relevance of the appeal waiver and what it means. Instead of doing that in this case, the court provided a perfunctory and confusing explanation of the appeal waiver, suggesting very strongly and erroneously that this suppression issue would survive the appeal waiver. And for those reasons, the appeal waiver was invalid, and this court absolutely can and should reach the suppression issue. Specifically because Officer Nunez's testimony here appeared to have been patently tailored to nullify constitutional objections. It does not make sense that an officer would see a man holding a gun and take zero measures to protect himself or his colleagues. According to his own testimony, Officer Nunez did not draw his gun, tell his colleagues about the gun, or even instruct the man holding the gun to put it down or keep his hands where they might be visible. Instead, according to Officer Nunez's own testimony, after exiting his car, when he was still directly adjacent to both of his colleagues, he allegedly saw Mr. Jackson holding a gun and then wordlessly walked away from Mr. Jackson, losing sight of both Mr. Jackson and the gun, and walked around the car to the passenger side of the car, where there was another man seated directly in front of the glove box, where the officer claims to have seen Mr. Jackson place the gun.
So you're asking us to reject the credibility finding of the motion court?
Yes, Your Honor. Because the testimony here was simply unbelievable. It does not make sense that a police officer would see a man holding a gun in his hand and walk away from that man, knowing that his colleagues, who were feet away, according to his own testimony.
Did I read the record correct that he also alleged that the man put the gun inside the glove compartment,
Correct.
that they then only asked the driver to step out, but left a passenger in the very car in front of the glove compartment with the gun.
Precisely, Your Honor, that's right. And not only that,
And you see, I wish I could get there, right? The problem is, I don't see how we get past the waiver. So while, look, there's no magic formula of words that a judge has to give, and admittedly, it wasn't a transcript of perfection, right? But we also have the written waiver, and the Court of Appeals has been very clear that they evaluate both, the combination of those two things, to make sure that the defendant understood. And I'm having trouble finding how I get to the place based on those two things, the imperfect colloquy and the waiver, the written waiver that was signed. How do I get past those two things to even entertain what I think are valid arguments on the suppression?
it's very simple, Your Honor. Here, the court didn't just fail to say the perfect thing, right? The court affirmatively said something wrong. The court said, included in its explanation of the appeal waiver, that included in the rights he was giving up, he was giving his right to quote, appeal a decision made prior to a pretrial suppression hearing that he was present in this case. Do you understand that? The court asks. Yes, says Mr. Jackson.
So, look, that statement was wrong on multiple levels.
Certainly.
But it doesn't even, because he doesn't say that the court could not consider, the way he says it is incorrect, but doesn't completely, he doesn't say the wrong thing specifically about the suppression, because what he should say is that the suppression hearing, which happened before, right?
Yes, that's exactly. So what he said is, what he suggested very strongly was that he wouldn't be able to appeal any decisions that the trial court had made before the suppression hearing or after the suppression hearing. And the written waiver was completely inadequate here to overcome the deficiency in the appeal waiver colloquy, because the court never ascertained whether Mr. Jackson had read the appeal waiver.
But doesn't the, oh, okay.
Or understood it, or discussed it with his counsel.
Got it, all right.
Thank you.
You may
Good
proceed.
afternoon, Emily Aldridge for the people. As Your Honor indicated, the appeal waiver does prevent reaching the merit of the suppression. Here, it is very important that the waiver of the right to the suppression hearing was specifically conveyed simultaneously.
But he doesn't say it right. What he says is incorrect.
Well, he initially says he would waive his appeal of the hearing. He's going to waive the adjudication of whatever the judge found. This is when the court first announces this plea, this very, very favorable plea agreement, in which he would be allowed to be sentenced to the minimum term to be served concurrently with his prior instilled conviction, despite the fact that they just had a conversation moments before about how consecutive sentence was mandatory. Then once they move on, and the counsel then says, I think, takes a pause, ostensibly to discuss the plea and the waiver with defendant, then comes back and says, we're interested. Then they go through.
Does the transcript reflect that there is a pause with counsel for him to discuss the waiver?
It asks for a moment. Does not say specifically what they're discussing at that moment. But then when the court moves on to the appeal waiver, it says included is that you're giving up your right to appeal a decision made prior, and in the record, counsel's correct, it does say made prior to a pretrial suppression hearing. However, it is worth noting that the stenographer is writing down the words as the court is saying it. It is not going to say any sort of pause, any sort of, there's no ellipse, there's no em dash. So it very well may have been included in that is the right you're giving up to appeal a decision made prior, pause, and then to a pretrial suppression hearing. So it seems to me the court is actually conveying that it's to a pretrial suppression hearing, and the court kind of reneges on the prior. Now, this is all, we're looking at the exact words typed here, but that is all the reporter is going.
Counsel, suppose we find the appeal waiver invalid. Why shouldn't we find that the judge erred in finding the officer credible, given all of the factors that counsel pointed out, that according to his testimony, he left two people in a car with a gun while he leisurely walked around the car. He did nothing to prevent any action being taken against him or his fellow officers from this gun. He didn't mention to his fellow officers that he believed there was a gun. Why wouldn't we find that was incredible?
And time and time again.
I'm sorry?
As this court has held time and time again, when it comes to credibility determinations, that credibility is best determined by the court who is able to see the testimony.
Ordinarily, but sometimes testimony is sufficiently incredible that we find something different from what the person hearing it found.
What's key in this case is that the defendant appeared to be storing or secreting or hiding the gun in the glove box.
The issue is whether the statements of the police officer make any sense, and they don't.
But in this particular instance, he was not, the defendant did not draw a gun. So in here, there was no reason for the officer to come out guns ablazing.
The officer said he saw a gun. I have never, in the 12 years I've been in this court, read any transcript where an officer says he sees a gun and he does nothing, doesn't pull out his own gun.
Well, and
so, counsel, this fact pattern recited by this police officer leaves a lot to be desired, and his credibility is questionable. He's only been found to have CCRB complaints substantiated several times. So I would not, if I were you, just skirt off of that.
Well, here, his efforts to prevent escalation of a situation did not render him incredible. He was putting the gun away. He was not threatening him with it in any way. And if he had come out guns blazing, then there'd likely be different allegations that are being made here. And regarding the CCRB did not find any bad acts or dishonesty, just that his prior actions were unjustified. That does not equal false statements or whether he spoke the truth here.
Counsel, one question. Did Officer Nunez at any point caution the two officers who were with him that he saw a gun placed in the glove compartment?
When asked on cross-examination whether he had notified his colleagues, he said he did not.
He did not?
He stated that he did not.
Thank you.
But that was not further.
That response in and of itself is incredible. That an officer would see a gun with other officers on the scene and would not advise them, beware, there's a gun, and require then, that would normally result in everyone drawing their weapons on every occupant in that car. Okay?
There's no further question.
I gotta tell you, to me, the strongest argument you have is valid waiver. That's it. Because the fact pattern here is very troublesome.
Thank you.
Counsel, I'll give you a minute.
Thank you, Your Honor. I think it's very telling that respondent relies on possible errors the stenographer may have made while recording the plea colloquy and the appeal waiver colloquy. And the reason, to be clear, why the written waiver was inadequate to cure the errors that the trial court made in its description of the appeal waiver is that the trial court utterly failed to ascertain whether Mr. Jackson had read the form that he had signed, had discussed it with counsel, or understood it in any way. Furthermore, even hypothetically speculating, which we are not permitted to do, that Mr. Jackson had read the form, why would we expect Mr. Jackson to trust the contents of the form over the words of the judge sitting in front of him?
Because the form is fuller and it says everything more spelled out.
I don't think it's reasonable to expect that Mr. Jackson would have, in the at most seconds he had to read the form, knowingly think, oh, I know better than the judge who's in front.
That's on counsel. Counsel should make sure that that happens ahead of time, right?
Unfortunately, well, actually, rather fortunately for Mr. Jackson, it's actually on the trial court. It is the trial court's responsibility to ensure that.
I understand that the trial court has the responsibility of making sure that the record is clear. It is the responsibility of counsel to make sure that when their client takes a plea, that they understand all of the ramifications of their plea.
Certainly.
Right?
But the Court of Appeals.
You don't need any additional argument. I got it. Thank you.
Thank you, Your Honor.
LaShawn versus Amanda T. Who will begin? Who's the appellant? Oh, the appellant is not here. Okay.
But the child's attorney is.
Let's start with the child's attorney.
Yes, Your Honor. May it please the court. In Brooke SB, the Court of Appeals said that the law in this area is to be developed on a case-by-case basis. This is a case that requires analysis in order to determine whether the precise holding of Brooke SB ought to be expanded.
Isn't the really critical case here Bennett versus Jeffries? Because it seems to me, as opposed to Brooke SB, because it seems to me that the best argument for appellant is that there are extraordinary circumstances here which would give her standing and thus allow her to be a party to the custody proceeding, and that the referee wouldn't permit her to put in evidence of extraordinary circumstances. So why isn't that the more critical case here?
It is certainly a good argument, and I think a winning argument, and that was the argument advanced by the counsel for the appellant. We came in to support the counsel for the appellant and didn't address that argument specifically because the counsel for the appellant had addressed it in detail. And what we wanted to do, and of course we're at a disadvantage because the appellant did not appear in this court, but what we were trying to do was to establish that under Brooke SB, this is a case for expansion of that case because this is a case that is very close to Brooke SB and that everybody had reasonable expectations that the woman who was in the relationship, who was not the woman who carried the baby, would be the mother. All of the evidence points to the two women having that understanding. And in addition to—
Is there any evidence that the biological father here was even aware of this arrangement?
Yes, Your Honor, there is such evidence, and that evidence appears on the second volume of the four transcripts, of the four testimonial transcripts.
Can you point us to a particular date or page or?
Yes, specifically, what are you talking about? This is a very large transcript.
Yes, I understand that. There are only 4 pages of actual trial testimony, and we referred to it in the brief as volume 2. So if you look at the footnote on page 7, the second day of the hearing was January 29th, 2021. Pages 6 and 7 and 27 and 28, the father understood that the mother, the biological mother, was in a same-sex relationship with someone else.
Yes, my question was, did he understand, and was he a party to this agreement that he would provide the sperm to create a child that these two women would raise and he would have nothing to do with it?
There is very good circumstantial evidence to that effect, Your Honor, because all of the facts that the court below found cannot simultaneously be true. There was testimony from the husband about, or the father about, going to prenatal visits that conflicted with findings that the court made about the non-mother mother, the other woman in the relationship.
The appellant.
How does that show that he knew? Were they at the hospital? Is there any statements in the record anywhere?
No, Your Honor.
I need to finish my statement before you can say
apologize,
no.
Your Honor.
That the father was at the hospital at the same time as LaShawn. Was there any evidence that showed that LaShawn, Amanda, and the father had a conversation about this arrangement, that there was an agreement that he would be a silent parent or non-parent to this child?
No, Your Honor, there is no direct evidence, but there's a good deal of circumstantial evidence. For example, the relationship between the father and the mother, and I'm using mother to mean biological mother, he found out that she was pregnant in late May of 2018, and the relationship broke up soon after. That suggests that he was really a sperm donor.
Was that because he claims that he found that she was texting someone else? And I'm assuming that that meant that he was jealous that she was carrying on with someone else while pregnant with his baby.
Well, there are but he knew it was a same-sex relationship, according to the...
That is of no consequence in my mind, whether it's the same sex or not the same sex. A relationship outside of a relationship is just that.
He delayed in bringing a custody petition because of the headache of dealing with the natural mother.
I understand he brought his petition within a month of this child's birth and within 1 day of the mother's death. Am I incorrect about that?
He brought it, I think, 2 months after her death, but in any event, it was right after she died. I mean, 2 months after birth.
Counsel.
There.
Sorry, I was taken aback. I apologize.
It's okay. To what extent does the appellant need to establish a preconception agreement? And under the circumstances provided, has she done so?
I don't believe she does have. I don't believe she does have to provide a preconception agreement. And as we state in our brief, Brooke S.B. says on the facts of that case, there was...
I can hear you loud and clear. You don't have to yell.
I'm sorry, Your Honor.
It's okay. The tech is very good.
Brooke S.B. says on the facts of that case, there was a preconception agreement. So that would mean, of course, that if there were a clear preconception agreement, we would be within Brooke S.B. But Brooke S.B. also says you don't have to have a preconception agreement necessarily, because the law is going to develop. And Justice Schenkman, in his commentary in McKinney, says it could be that all sorts of arrangements would be within the ambit of Brooke S.B.'s rationale, and it's to develop on a case-by-case basis. Here, it's clear there was a preconception agreement between the two women. Brooke S.B. only had two parties. It only had the two same-sex partners. Our case is different, and so the question then analytically, may it please the court, is whether on the facts and very different facts of this case, and I'm talking now apart from what Her Honor said earlier with respect to extraordinary circumstances, the question in this case is whether the rationale of Brooke S.B. ought to be extended to the facts here. And if you look at a continuum between reasonable expectation that the non-carrying same-sex partner should have standing, because this is not the determination of custody. This is only about having a seat at the table in the courtroom in family court. Whether that person should have standing, then the answer to that question on the facts of this case, looking at the rationale of Brooke S.B., is yes.
My colleague has a question.
I have one more question.
Judge Gonzalez, Judge Gesmer has a question. Hold on, please.
So in terms of remedy, if we were to agree with you, are you asking that this be remanded for a further hearing on standing?
No, Your Honor.
Or that it go ahead to a hearing on custody on the theory that appellant has adequately proven that there was an agreement? Is that your theory?
My theory is there are two arguments, and
Well, I'm trying to figure out exactly what it is.
And I need you to
I'm sorry.
please observe that your red light has been on for about 4 minutes already.
I know, I'm trying to
Please
be.
respond
Yes.
but
Yes, Your Honor. On the extraordinary circumstances, there is standing. If you find extraordinary circumstances, standing follows automatically. On the Brooke S.B. Branch of the argument, there would be, if you agree with us, there's standing, it would go back for a hearing on the merits of custody and visitation.
Thank you.
So can I ask my question too?
Go ahead.
Thank you. So in your view, does the appellant have to establish in any way that she is a parent? And if she does, are you asking us to expand the definition of parent?
The answer to the second question is yes, parent is somebody, you have to be a parent as used in domestic relations law, section 70. But what is a parent has moved in the course of time. Brooke S.B. specifically said what is a parent is defined in terms of the best interest of the child and with reasonable balance of a continuum to be established on a case-by-case basis. Our position is she is a parent under the criteria of Brooke S.B. and domestic relations law, section 70.
Thank you.
Thank you, Your Honor.
I'm giving you 7 minutes since we went over.
I appreciate that very much, Justice. My name is Michael Weinstein from the Neighborhood Defender Service of Harlem, and I'm here for the respondent, Mr. M. Good afternoon, Justices, and may it please the court. This appeal concerns a father's journey to finally becoming a parent again after many years of effort.
But we understand that your client sees himself as on this journey, but what I'm concerned about is this. The referee said, this is a standing hearing. We would get to the issue of extraordinary circumstances at some point after we're done with the issue of standing. Isn't that an incorrect statement of law? Isn't extraordinary circumstances an element, one way of proving standing?
Sure, and I'm very glad that, Justice Gesmer, you asked me that question because I wanted to respond to it before. Bennett versus Jeffries absolutely applies here.
Right, so under Bennett versus Jeffries, isn't the issue of extraordinary circumstances one way of proving standing?
We agree. And
so wasn't that an erroneous statement of law by the referee?
Yes.
So why shouldn't that require us to send it back so that it can be tried under the correct standard of law?
The circumstances of this proceeding, the hearing went on for 2 years.
Well, we understand that, like many family court hearings, this went on a really long time, and that's certainly unfortunate. But given that you agree with me that the referee applied the wrong standard of law, shouldn't we send it back for a hearing on standing?
Now that the child has returned into, or rather now lives with Mr. M, the possibility, given all the evidence that has already been entered.
Lives with whom?
I'm sorry, Justice.
I didn't hear you.
Oh, sure. Now that the child, Jelani, is with Mr. M for the first time,
okay,
the likelihood that there is any evidence beyond what has already been introduced into the record to show extraordinary circumstances is unlikely.
But that's not how we don't consider evidence it's not before us. And what we have in front of us is a record of a hearing where the referee said, extraordinary circumstances are not what I have to think about. Shouldn't we send it back so that the referee or whoever gets it now considers that and then proceed from there? I understand that things may have changed, but still, we have to deal with this as a matter of law.
I'm sorry, please let me know if I should pause for the video to return.
Oh, boy.
Oops.
Hold on one moment, please. I want to make sure she's able to hear.
Of course.
Could you please have someone in the clerk's office call Judge Gonzalez and let us know whether she is able to hear the argument so that we can proceed? Thank you. You may want to have a seat until we get the answer back if you like. And let me pause your clock.
Meanwhile, my computer is bad.
Technology doesn't always work.
Usually my computer's perfect on the bench. Just not.
Apologies. I think we got her back.
There we go.
Was it something I said?
No, I think what we are going to do, because this is recorded, so my colleague will be able to retrieve the rest of the argument. What she won't be able to do is ask any questions unless she emails us, okay? So Judge Gonzalez, if you hear us and you have a question, just email one of us on the bench. I believe Judge Gesmer has her computer. Why don't you proceed?
To continue with your question, Justice Gesmer, that's certainly a possibility. There is another matter that is confronted here, though. Under DRL 70, there can only be two parents of a child. This was...
There are only two parents now who are a possible resource, the appellant and your client. So there are no longer three parents in the picture, three potential parents.
I think we're talking about first going back and establishing standing. I understand that he's now living with his dad, and that would be for consideration when custody down the line after this. But right now, we're just talking about her opportunity to be there.
Of course. And so Brooke SB, Justice O'Neill-Levy, and Bennett versus Jeffries work in the same world but emanate from two different places, with Bennett versus Jeffries having come into being as a matter of a grandmother who had a child and a mother who wanted that child back in her care. Here, there was some discussion about Brooke SB before. This matter is akin to Brooke SB, but the companion matter is in Estrellita A. In that proceeding, there were two individuals who may or may not, who had a co-parenting agreement. Of course, that was on appeal. And estoppel was used in that proceeding because one of the individuals had filed a child support petition, and child support was granted, and then was attempting to negate the other individual's capacity to parent. What we have here is Mr. M went to court and filed his paternity petition in early March. And just to clarify the dates, I just want to make sure I get it right. On March 1st, Mr. M filed for custody, which was 2 days, I forget if it was a leap year in 2018, the custody petition after Ms. T passed away. 3 days later, that was when Ms. K first filed for custody on March 4th. And there was a subsequent petition on March 5th, 2019 for visitation. It's unclear, and the court couldn't clarify why the visitation and custody were spread out. But there was nothing done by Ms. K to contest or even file for paternity herself. I understand that historically, the term paternity has meant to be a male, but as the state of New York has begun to move away from the gender-specific terms, certainly Ms. K, based on the claims she was even making in this proceeding, could have argued that as a matter of estoppel, that she was this child's father, as she so claimed. And I'm using the terminology that Ms. K used, but did not. And Mr. M was established through an order of affiliation, therefore there is estoppel, that he is Jelani's father. Additionally, there's another aspect of this. An Article 10 proceeding was filed in August 6, 2019, against Mr. M concerning Jelani. That Article 10 petition was only filed and converted from originally the destitute child petition because Mr. M was established as Jelani's father. In that proceeding, despite the attorney for the child's awareness that Ms. K wanted to serve as a resource for Jelani, never brings up Ms. K once in that proceeding. And we know that in Article 10 proceedings, the capacity to and standing to be able to put oneself forth, regardless of even biology, as a child's resource, is much more universal. It's much more available in that proceeding. And yet Ms. K did not do that there either.
Okay.
If there are any other questions, I'm happy to answer them.
Well, thank you.
Thank you, Justices, for your time.
Thank you, Harms.
Thank you. Beller versus Tao.
Good afternoon, Jesse Conan for the plaintiff appellant, Albert Baylor. The trial court here erroneously granted defendants' pre-answer motion to dismiss. And there are really only two issues before the court. One is the 2012 put option agreement between Tao and Baylor sufficiently definite to form an enforceable agreement? And two, did the merger...
Now, before you get to that, at the point in time that your client made the investment, right, in defendant's company, he had some apprehension about doing it the way that the defendant wanted to do it. Am I right?
That's correct.
But he relented and went along and invested his $3 million ultimately through the company DigiPack, correct?
Correct.
And at the time that he invested through DigiPack, am I correct that he was aware of the terms of the LLC agreement of DigiPack? Did he know, for instance, that his friend was the sole member of DigiPack?
I'm not sure what he specifically knew or didn't know about DigiPack. I don't think that's necessarily part
Well,
of the
it is
record
relevant
here.
because he's making his investment through that company, and so the terms of that agreement would control how that investment goes, no?
Well, they had a separate oral agreement.
Yes, but it would be in conjunction with whatever the operating agreement of the LLC was, correct?
Well, I think it would, to the extent that there were inconsistent terms there, I think it would supersede whatever was in the operating agreement from 2012. So I don't think it was necessarily so important for him. But again, I think we're a little bit outside of the record.
Well, that's for me to decide whether we're
fair
outside
enough.
the record, right?
He had...
So if indeed the original LLC said, and it does, by the way, that the defendant is the sole member and has sole authority to make amendments to that LLC, why would your client not be bound by that?
Well, at the point where Mr. Baylor and others become members of that LLC, Tao is no longer the sole member of the LLC. Now, the LLC agreement explicitly provides what happens if Tao transfers all of his interests to another party. But it doesn't explicitly provide what happens when other members join. It doesn't really consider what to do with other members. And Delaware law has certain rules in place where the agreement doesn't explicitly provide for an alternative. Delaware law has specific rules in place as to how you're supposed to amend an agreement. And what Delaware law says is that...
You're saying that Delaware law would say that if your agreement has very specific provisions about how this happens, Delaware law makes those provisions non-existent?
No, what I'm saying is that if there's an ambiguity in
What's
the
the
contract...
ambiguity here?
Well, the
statement said that the defendant is the sole member who can amend, rewrite, etc., the LLC. That seems pretty clear to me. There's no ambiguity there. He's the sole member who can do that.
But when other members join, he's no longer the sole member.
Well, it depends on what the LLC is, if the LLC is changed.
Well, the LLC has, the agreement, it's a two-page document, and it has provisions as to what happens if Mr. Tao transfers all of his interests. But it doesn't explain what happens when he transfers part of his interests. And I think that that's a gap in the agreement. It's an ambiguity in the agreement. And what the rules of Delaware say is that where there is an ambiguity in the agreement, that ambiguity is to be interpreted against the drafter. And it's to protect the minority members of the LLC, in this case, Mr. Baylor and perhaps others. So I think that the amendment itself was not effective by the agreement's own terms. But there's a lot of other reasons why that specific, why the amendment was not effective as to terminate their side agreement that he entered. For instance,
Go ahead, keep going. Don't
Sure, sure.
worry about the light. Go ahead.
Yeah, fair enough. First, the relinquishment, the rules in Delaware and New York are in agreement that the relinquishment of a valuable contract right must be unmistakable, voluntary, and knowing. Courts aren't just going to find that a very valuable contract right has been terminated or extinguished without a clear signal from the party that's actually giving up that right. And at the time that the 2014, at the time of the 2014 amendment, that put option right was worth about $11 million.
Counsel, can I ask you, was the oral agreement between Mr. Baylor and Mr. Tao, or between Mr. Baylor and Digipac?
It was between Mr. Baylor and Mr. Tao.
Okay.
Who owns Digipac? Mr. Tao?
Well, the members own Digipac.
Huh?
The members own Digipac. So at the time...
And there was one sole member.
Well, in 2012, it was Mr. Tao. As soon as Mr. Baylor transferred money to purchase shares of Digipac, Mr. Tao was no longer the sole owner. And in fact, there were lots of different investors in Digipac.
Counsel, is...
Sure.
Let me turn back on my mic. Thank you. If I may, can we discuss the subject matter of the exit opportunity agreement and the amended, restated LLC agreement? Is there any relationship between the two? Do they cover the same subject matter or something else?
Well, the exit agreement was a side agreement between Mr. Tao and Mr. Baylor to essentially, Mr. Tao wanted Baylor to invest in his company. Mr. Baylor was unwilling to at first, but he received promise from Mr. Tao as to allow Mr. Baylor to exit that agreement if certain triggers were met, either if the shares of the derivative
Went
publicly
above
traded
50,
company
right?
was hit $50 a share or at 5 years. And once he got that agreement in place, he agreed to transfer the money because he got the assurance that he wanted. In 2000,
For payment by Mr. Tao.
I'd like to ask a question if I may. Sorry, I just got camera access like 2 seconds ago.
Sure.
If the agreement, the oral agreement and the amended agreement are seen as separate contracts, which is an argument that has been made with different subject matters, what was there separate consideration for each?
well, there was no consideration for the amendment to the operating agreement because Mr. Tao just unilaterally imposed that on its members, on Digipac's members. The consideration for for the side agreement between Mr. Baylor and Tao was that Mr. Baylor invested $3 million in Mr. Tao's LLC. So there certainly is separate consideration and a separate subject matter of the two agreements, and I think that's just one of several reasons why.
So when you invest in an LLC, aren't you subject to the terms and the agreement of the LLC?
Typically, yes.
Does that case, Seaport Village, that Delaware case that Judge Barak cited, is that contradictory to the argument that you're making now?
I think he just more or less stated the general rule that if you are a member of an LLC, you're subject to the rules of the LLC. But there are rules about how agreements can be amended. There's limits. Surely Mr. Tao, because he was the
But aren't those limits dictated by the terms of the LLC itself? If an LLC has very specific terms about how an agreement can be amended, modified, etc., then so long as the parties stay within the confines of that language, then the amendment is okay.
Sure.
And I have not heard that this amendment violated the language of the LLC.
Well, there are other considerations, because even if it didn't violate the language of the LLC, there's limits on what Tao is allowed to do. Surely he can't include language in the LLC that requires Baylor to just transfer $30 million to him. There's limits about what he can do as the managing member of the LLC. There necessarily have to be. And here, what Tao did is he extinguished a very valuable obligation that he personally had, or he tried to,
Right.
at least theoretically. Now, I think his conduct is inconsistent with that because I don't think the merger clause actually reaches the side agreement. And Tao, between 2014, right up until this motion to dismiss was filed, acknowledged his obligation to Baylor. He conceded in numerous discussions that he owed Baylor
That's
this
probably the
obligation.
strongest argument you have. Go ahead.
And he, and after,
Yeah, my colleague has a question she's been dying to
waiting
ask.
a long time, I
Go ahead.
apologize.
So since the oral agreement was between Baylor individually and Tao individually, is it your understanding of the oral agreement that the payment that was due to Baylor was from Tao individually or from Digipack?
Well, it was Tao individually in that he was responsible for making sure that the payment happened. Where he got the funds,
Come
I don't
on.
think that matters.
He made an investment in Digipack through Digipack for Remark. So clearly, that is how his investment gets paid, not some magical.
Well, it's not magical. He had a separate agreement with Mr. Tao.
What term in that agreement said you will personally pay me out of your money, as opposed to
He's the only party.
Well, it didn't specify how he was supposed to make that happen. He could surely, if he wanted to, he could sell the shares of Remark and use Digipack's assets to cash out.
In fact, that was option one, sell my shares, right?
That's certainly something he could have done, but he had the discretion. Every contract confers a bit of discretion on the performing parties, and Tao had discretion as to how he was going to come up with the money, how he was going to make the cash out happen. I don't think that discretion makes the agreement indefinite or improper, because
You'll have 2 minutes on rebuttal, okay?
Good afternoon, Your Honors. Karen Klein on behalf of Respondent. Now, there are two independent and sufficient reasons to affirm this appeal. Number one, the alleged agreement was indefinite, and number two, the LLC agreement barred the enforcement of the alleged oral agreement.
So are you saying that Mr. Tao entered into an agreement with Mr. Baylor, which he knew was barred by the LLC agreement? At the time you just said that, correct me if I'm wrong, but I understood you to say that the oral agreement was barred by the LLC agreement.
Correct.
By the second one.
By the second, but are you saying it was also barred by the first one?
No, Your Honor, we're referring to the terms of the currently operative LLC agreement, which was properly amended pursuant to the first LLC agreement. Or alternatively, Mr. Baylor's counsel did not address the fact that in 2019, 5 years after the amendment, he invoked the amended LLC agreement, sought documents in a document demand under its terms, and received those documents. So even if it wasn't initially in effect, it was ratified by his conduct.
Okay, so here's what I don't understand. If the oral agreement, as counsel contends, was between Mr. Baylor and Mr. Tao, then why does the amended LLC agreement affect that? Because it was not, the amended LLC agreement affects what the LLC can do, but it doesn't affect what Mr. Tao can or must do under an agreement he made in his sole name.
Well, it relates to the operation and management of Digipack.
Well, no,
And the
all
members'
it did, I'm
investments
sorry,
in
excuse me,
Digipack.
I don't see how it does that. All it does is say that if Mr. Baylor wants his money, Mr. Tao has to pay it. And that doesn't relate, it doesn't say where it comes from or whether it affects Digipack or that he's entitled to get it from Digipack. So I don't understand why that is governed by the LLC, the amended LLC
Because
agreement.
the agreement as alleged in the complaint was not, I will pay you the value of your investment. The alleged agreement was, I will provide you an opportunity to exit your investment, which means no longer be a member. And the terms of his membership are governed by the operative LLC agreement. And the specific terms of the LLC agreement are in conflict with the concept that Tao somehow could provide this exit opportunity unilaterally or had the obligation to do so.
But counsel, your client is trying to take advantage of an amendment. He made the agreement with
Baylor.
Mr. Baylor. He made the agreement. He knew at the time he was the sole member. He chose to unilaterally change the terms of that agreement.
Allegedly, he did. Allegedly, he did.
Not allegedly. Where is it anywhere in the record that someone else made these changes?
Well, but under the initial operating.
And according to the agreement, only he can make the changes. So it's not allegedly. He made the changes.
He did.
Correct?
He did. And Mr. Baylor agreed to those changes.
No, he
in
didn't.
two respects.
He
In
did
two
not.
respects.
When your client attempted to get him to sign the new restated amended agreement, he refused because your client had unilaterally changed the entire agreement.
So, but there's two responses to that, Your Honor. Number one, Mr. Baylor, when he became a member of Digipac, signed on to the initial operating agreement, which specifically said that Tao had the authority to amend.
Is there a signed document in the record? Is there a signed document in the record?
Signed by Mr. Baylor, there is not, but there does not need to be under Delaware law. Delaware statute.
But you
specifically-
said he's. Can I finish, please? Give me a second, Liz, please.
Sure.
Because I want to just follow up with what you said. You said he signed the agreement.
I'm sorry, he signed on to the agreement. He didn't physically sign the agreement, or at least that's not in the record.
So he
However-
signed on to the agreement
Yes.
by giving his friend $3 million to invest in his company. Is
That's
that? You
Sorry, Your
really
Honor.
have to let us finish our sentences before you cut us
Sorry, Your
off.
Honor.
This doesn't work otherwise. Okay. So he signed nothing, no physical paper beyond just wiring $3 million to your client?
Not that's in the record, Your Honor. However, Delaware law is very clear that a member of an LLC does not need to sign the LLC agreement for it to be binding against him. All he needs to do is when he makes his investment, he becomes a member and that agreement is binding. It doesn't matter whether he physically signs it or not.
Does it require, under Delaware law, proof that he was aware of the terms of the LLC?
It does not, Your Honor. He makes the investment.
All right, is there any evidence in the record that a copy of this LLC agreement and the terms of the LLC were known to Mr. Baylor?
The original or the amended?
The original. Because to me, if he knew the terms of the original, knew that his friend could change the agreement and basically divest him of his investment, then he owns that. Did he know? Was he aware? Was he provided with a copy of this LLC before he gave his $3 million?
That is not in the record, Your Honor, but again, it's not dispositive because by choosing to make the investment, and if he didn't say, I want a copy, it's on him. If he says, I'm making this investment, I'm giving you $3 million, that's on him. And again, he still hasn't addressed the fact that 5 years after the amendment, and after he received a copy of the amendment, he invoked the amended LLC agreement and said, I want documents pursuant to these two provisions of that agreement.
Now, a question. The original LLC, would he have been entitled to those documents under that original LLC anyway?
No, Your Honor. It
No?
didn't provide for specific documents that are required under the LLC agreement. The amended and restated LLC agreement has provisions that explicitly identify the particular documents, among others, that the company is required to give on a request.
And that wasn't available on the first?
That provision did not exist in the first LLC agreement.
All right.
One other thing I would just like to say, Your Honor, if I may.
Can I ask a question now?
Yes, you may.
Thank you. I can't see the judges, just so you know. I can only see you.
Okay.
Okay. So the original agreement says that Mr. Tao was the sole member of the LLC. Am I right?
That's correct.
At what point does Mr. Baylor become a member of the LLC?
Mr. Baylor became a member of the LLC when he made his investment. I believe it was later in 2012, so it was later that year.
And to the extent that that Mr. Tao is not the sole member of the LLC, was his signature required to ratify the amended LLC agreement, in your view?
Mr. Baylor's signature?
Yes,
It was not required, Your Honor, because under again, I think appellant's counsel is confusing the term sole member a little bit. Sole member is a defined term in the initial operating agreement to mean Mr.
Yes.
Tao. So because he sold some of his membership interest to Mr. Baylor, he did not cease to be the sole member as that term was defined in the agreement. I know the use of that term because it says sole member sounds
I'm
to be
sorry, I'm
descriptive.
sorry. Are you saying that there can be a sole member plus members?
Yes, Your Honor. Unfortunately, that's the way that it was.
Really?
It's a defined term to mean Mr. Tao unless he transfers to an individual or an entity all of his membership interest. That's what it means. And Mr. Baylor alleged that he got 24%. He doesn't allege he got 100%. So Mr. Tao, there's no allegation that he wasn't as defined in the agreement, the sole member, even if he wasn't the only member. It was a defined term. If I just made just the one point I wanted to make quickly, Your Honor, it wasn't discussed today, but in the reply brief, appellant made a lot of noise about an alleged fraud that was raised for the first time on reply. It was not pled in the complaint. There's no allegations of fraud in the complaint. It should not be considered by this court. Thank you.
Thank you. And I'm keeping you to your 2 minutes. Okay.
Understood. Well, first of all, the request for documents in 2019, that request was made after Mr. Tao admitted to Mr. Baylor that he had breached the agreement, and that request was, all the court has is 4 letters from Mr. Baylor's counsel where requests for documents were made, and those requests were apparently seemingly denied. There's no evidence in the record that any documents were provided, so nothing can be taken from those requests. We don't know what was provided, and Delaware law under statute requires certain information to be provided to members, and it's not clear whether that was the information that was provided or not. Now, but even if this merger clause is enforceable as to Baylor, in some capacity, it still doesn't reach their separate side agreement. A standard merger clause such as that one it unambiguously precludes parole evidence, which is negotiations that lead up to the final agreement. Those typical merger clauses don't reach agreements that were entered 2 years earlier with a different focus. And had the signed agreement been explicitly mentioned in the merger clause, maybe there'd be an argument here. But unlike the specific reference to the original operating agreement, the merger clause did not reference the side letter. And again, enforcement of the merger clause is inconsistent in the manner that the defendant wants the court to enforce the clause, is inconsistent with his conduct between 2014 and 2020, where he admitted and conceded his obligation to Baylor. Had he intended the merger clause, and he's the only drafter, had he intended that merger clause to cancel that obligation, he surely wouldn't have made those concessions. So either he was lying to Mr. Baylor the entire time, or the merger clause didn't reach the side agreement.
Okay. Thank you so much. Sure. Caldwell versus 4NYP Ventures. You may proceed.
Good afternoon, Your Honors. My name is Daniel O'Connell, and I represent ABM Janitorial Maintenance and defendant appellant. I want to deal with the aspect of our summary judgment motion. We moved for dismissal of the claims of failure to preclude insurance, as well as contractual indemnity, and then on the main, on the claim that we're liable to plaintiff. I would like to deal in the first instance with the low-hanging fruit here. So there are some things I believe that are easily able to be ascertained on the appellate level because the law is well settled that a policy that includes a blanket endorsement for additional insureds is enforceable. Here we provided on the record at 2491 through 2755 the entire insurance policy that we had in place as independent contractors, commercial with all the aggregate limits, and we also provide the certificate of insurance, which I identified the owner/owner's agent, CBRE. So I believe by saying that everything in the there was a transcript attached to decision by saying that everything that we did not decide
I'm not sure if,
is denied.
is she gone?
Continue, go ahead.
Okay, so because, and it may have just been inadvertence, because the issue of the failure to procure insurance was not decided, it was denied. And I'm saying on the evidence, and there was nothing to rebut that we actually had insurance, that should be it should be reversed.
Okay.
Second, contractual indemnity. I think it was overlooked by the trial court judge when he said that we have to reach the issue of liability in order to reach the decision of contractual indemnity. Now, however, the law is pretty clear that the terms in the first instance of the indemnity agreement, that you look at the language of that agreement to see if it has been triggered or if the incident applies. And what I'm saying here is that we had language that says it has to arise out of or been done in connection with the indemnity agreement. And what I'm saying here is that the agreement that has been challenged that gave rise to the alleged injuries was a side agreement, not between CBRE, the agent with whom we contracted for, who they contracted on behalf of the owner, NYP. It was a side agreement that had to do with the tenant, which was JP Chase Morgan. Also, the deponents all conceded, the key ones, the CBRE deponent said, oh, this was for additional services. This was a side agreement. So it is our argument, and I believe it was ignored, and I think there was a First Department case that came in not too far after this, Kogan or Cobalt or Kogan, anyway, that also talks about triggering that you have to go within the language, and if something is additional services or is outside the contract, it cannot be indemnified.
Counselor, if I may, did you, rather your client, seek summary judgment below on the failure to procure insurance? Did you do that?
I believe we did. If I am wrong, however, it has been routinely held that where a claim for failure to preclude is challenged and the agreement and the certificate and the certificate, in our instance, certificate of insurance is produced, is not sustainable. So if they moved on it pre-judgment, they don't get it.
So you don't have to move?
I know.
Because I didn't think you did. That's why I'm asking.
He didn't.
Yeah, that's why I'm asking the question. That's why I asked the question.
I believe we moved, and I believe we
You did not move.
use it in our
did not
opposition
move.
papers.
You did not move for summary judgment on that issue. You contested their application.
That's why I asked the question.
Okay, because there was reference to our saying it's already in the record. So on the final issue of our liability to plaintiff, if I have a little time left,
You have 35 seconds.
I
Go
will
ahead.
quickly argue that on the issue of whether or not that we entirely displaced the owner's liability, that cannot happen when the owner's agent shares responsibility for the premises. And they admitted in the deposition testimony that they supervised and monitored ABM's work, in addition to the fact that this was for.
Yes, but there's nothing in the record to controvert the fact that it was your client who pulled the shelf and caused the collapse of the unit.
Except for, Your Honor, if I may, it is our position that the deponent, may I continue, plaintiff testified that there was a screech, and then they turned around, he turned around, and everything was falling. And on pages 419 through 424, and there's a little something on page 424, it was very clear when the deponent initially testified, it was a sound, then he turned around and saw falling objects and a body, and then later, after he was led, he contradicted himself and said he saw this gentleman who was an employee, I believe, of Chase, pulling of us,
Of
excuse me,
ABM.
of us,
Yeah.
pulling on the shelf.
Right.
You cannot hear a screech, see things falling, and then afterwards say that if they're already falling when you've turned around, it is not possible to see them being pulled out of the wall.
All right.
He was led, okay,
Thank you. You'll have time on rebuttal.
a feigned issue of fact.
You may proceed.
Good afternoon, Your Honors, and may it please the court. My name is Lauren Bryant, and I have the plaintiff respondent appellant. With respect to ABM's appeal, Your Honors, this court should affirm the denial of summary judgment to ABM on the issue of liability. ABM launched a force or instrument of harm under the Espinal exception in and as much as plaintiff testified that he walked
How do
into
you
the
address counsel's argument that the testimony by the plaintiff was inconsistent in terms of the sequence of events?
It's not inconsistent, Your Honors. If we start on page 422 and going into pages 423 and 424, the plaintiff testifies that he walks into the storage closet. One of the ABM porters pointed him to the back of the room. He hears a screech. He turns around. He sees the ABM porter pulling one of the metal shelves units right off of the wall. At that point, the shelf breaks apart. The shelf hits plaintiff, and then the plaintiff slips on the shelf after it's fallen on the floor, and that's how the plaintiff injured himself. It's not a feigned issue of fact. There's nothing to controvert the plaintiff's testimony in this regard. So that's the only evidence that we have, that he witnessed an ABM porter pulling the shelves off the wall. And specifically, the record shows that ABM was actually prohibited from removing the metal shelves from that storage unit. And so in that vein, Your Honors, ABM launched a force or instrument of harm. They can be held liable to plaintiff, and summary judgment was properly denied. With respect to 4NYP and CBRE, Your Honors, this court should reverse the award of summary judgment. Critically, Your Honors, and I believe this was going back and forth in the briefs, but I want to be really clear about this. Our expert and plaintiff's testimony is uncontroverted, that the metal shelves are attached to the wall via clips, and those clips are screwed into the metal posts, if you will, holding the shelves to the wall by nuts or screws. The term is used interchangeably. Plaintiff testified on 427, 432, and 499, consistent with Mr. Krongelb's, our expert's inspection, that there were no screws securing those clips to the posts. That, our expert found or opined, rendered the shelves unsecure, and that, in conjunction with the ABM porter pulling on shelves that were already not secured to the wall, is what caused the accident in this case. It rendered the shelves unsecure, and it made them break apart, come down from the wall, hit plaintiff, and cause plaintiff to slip and fall. Based on that, Your Honors, the owners here for NYP and CBRE were required to show that they didn't create the dangerous condition. And if Your Honors review the record, you'd be hard-pressed to find any evidence whatsoever as to who actually installed these shelves. We have testimony from the plaintiff that the shelves were installed by an unnamed maintenance individual 4 months prior. We have testimony from CBRE's property manager that 6 months prior, the shelves were installed. CBRE had installed similar shelves for JPMC on prior occasions. However, the CBRE witness didn't know whether or not CBRE had installed these shelves, whether or not they installed them on behalf of landlord. In fact, I think the only evidence in the record is that Americon was not the entity that installed the shelves. Because of that, Your Honors, CBRE and landlord can be held liable to plaintiff for creating this dangerous condition in the storage room.
Thank you.
Thank you.
Thanks. You may proceed.
Good afternoon, Your Honors, and may it please the Court. Melissa Danowski on behalf of the defendant, third-party plaintiff, respondent for NYP, the property owner, and on behalf of CBRE Group, the property manager. I want to first address, and then I'll address ABM's argument about the failure to procure insurance claim, but I want to address the contention that allegedly the owner or its agent, CBRE, constructed the shelves or put them together. There is ample evidence in the record that they did not. I think there's three things. So we have the testimony from the CBRE project manager, Mr. Clark. We have the plaintiff's own testimony, and then we have the fact that there was no work order generated by CBRE, which would have occurred had they actually done the work. So I think the confusion with Mr. Clark's testimony is he wasn't sure the exact whether it was an outside contractor, and if so, who, or whether it was JP Morgan's own on-site engineers that they had through their private personal facilities management company, JLL. But he was adamant. So Mr. Clark testified, yes, in the past, CBRE had installed some shelves for JP Morgan when it was the owner of the building. That was prior to 2012. 2012, JP Morgan sold the building, and then they came back as a tenant. Plaintiff's testimony says quite clearly that those shelves were installed sometime in 2014 or 2015 once they moved into the 12th floor. He testified to that on page 1415 of the record. So the shelves were installed after. So Mr. Clark then testified very clearly on page 1078 of the record. He's asked, question, so you can't recall with any certainty after the change in ownership if your company, CBRE, or the owner had installed the shelves? And he answers, yes, I can. For certain, we have not done it for JP Morgan since the building was sold. So these shelves in the 12th floor storage closet were not installed by CBRE. So there can't be any viable claim based on creation. There also is no viable claim based upon launching a force or instrument of harm under Espinal. There was no constructive notice, and CBRE can't be held liable for ABM. This was, counsel admitted, an extra contractual project. It was outside of the normal maintenance and janitorial services of the building. And
in either case, ABM is a independent contractor, correct?
Precisely, Your Honor, exactly. And another important fact here, too, is that in the lease agreement, this was JP Morgan's closet where they stored confidential materials. The lease provided that JP Morgan had a right, and this is under Article 6 of the lease at page 2254 of the record. JP Morgan could restrict any area, and the landlord shall have no obligation to provide any cleaning or other services in such a restricted area. This is precisely the closet that we're talking about. There's ample testimony that Ms. Joseph from JP Morgan Chase, she controlled who inside and outside of JP Morgan could have access to this closet. And there's testimony, plaintiff corroborated that as well at page 401. And so they were able to do that, and they did do that in this case. So it's just not reasonable to try to impute constructive notice or any obligation to maintain the closet on the owner or the property manager because they simply didn't have access or routine access to this closet. And then with respect to ABM's argument that, so there's no basis for dismissing the claim with prejudice that they failed to procure insurance. So they were required to do two things, and they only did one. Under ABM's contract with the owner, they had to name for NYP and CBRE as additional insureds. They did that part, but they did that on an excess policy. What ABM failed to do and is absent from the record is the second very important obligation, which was to provide a $1 million in primary insurance coverage through a commercial general liability policy. So because they failed to do that, there's no basis for them to have summary judgment on the merits on that claim.
Thank you.
Thank you.
Okay, you have 1 minute.
I'll be quick, I promise. So just in rebuttal to the deposition testimony that was taken and read by counsel after the testimony that I referred to, she referred to page 424 of plaintiff's deposition. I'd like to read from page 419, lines 15 through 23. I went to the back of the room to look at the boxes, and as I was looking in, I heard a screech. I turned toward the screech. I saw the shelving coming right at me, falling from the side. I kind of stepped back. The shelving went all over the place. I stepped back, and the shelves that came off the thing and went flying. Also says, at the point that you saw him, was your body turned around? Yes, as the shelves were coming down. And I also would like to mention, since there was an argument made that was not fleshed out here about the landlord being out of possession, that CBRE had a physical presence in the building. In addition to monitoring my client and supervising the activities, CBRE had a physical presence in the building, and that's at 1548 through 49.
Thank you.
Your Honors, in rebuttal to the owner's argument, still on page 1588 of the record, we have testimony from Mr. Clark saying again, I'll just reiterate that he does not know whether or not these shelves in question were installed by CBRE. So at most, at bottom, we have tribal issues of fact here with respect to which entity or individual installed the shelves. And I would stress that the absence of evidence in this regard does not meet the defendant's prima facie burden. They are required as summary judgment movements to demonstrate that they did not create this dangerous condition. And we have no idea which entity installed the shelves. We have a plethora of evidence that possibly the landlord or CBRE installed these shelves. With respect to CBRE's control over ABM's work, the record shows that this was not a lack of control here, and that CBRE and landlord can be held vicariously liable for ABM as its agent, because JPMC made the request through a CBRE-specific portal. CBRE specifically approved the request, generated a work ticket, assigned the work to ABM. ABM confirmed the work with JPMC, and then after it was all done, CBRE is supposed to go back and check ABM's work. So CBRE and also the landlord can be held vicariously liable for the acts of its agent, ABM.
Thank you.
Thank you.
And last but not least, People versus Angel Diaz. You may proceed.
Good afternoon, Your Honors. Nathan Brown on behalf of Angel Diaz. As my adversary conceded in their brief, the prosecution failed to present clear and convincing evidence of the complainant's age at the SORA hearing, warranting 30 points under Factor 5. The court below noted this absence when it suggested that a birth certificate or something proving the complainant's date of birth was needed, but ultimately relied on an erroneous representation by the prosecution that the grand jury testimony included a statement of the complainant's age.
Why isn't that sufficient?
It was an erroneous statement.
Sorry?
It was an erroneous statement. The grand jury minutes don't include such a statement. In fact, the grand jury declined to indict Mr. Diaz on any charges where an age of 11 or less was an element. And this is particularly significant where there are alternate subsections to charges in which he was indicted that include an element of age 11 or less, and the evidence that those would be applicable charges were evidently rejected by the grand jury. And as this court well knows, the guidelines suggest that when somebody is not indicted on certain accusations, that may be strong evidence that those accusations are unfounded. Of course, in order to correct this error, my adversary now, years later on appeal, seeks to rely on evidence that is outside of the record. And in order to do so, they conflate a number of issues. They redefine what it means for something to be, quote, before the court. And these efforts completely undermine fundamentals of appellate law, of appellate practice, and obliterate their evidentiary burden, their due process requirements by statute and constitution. The basis of this argument is that the SORA court is in possession of the criminal court file, and that makes that every document in that file necessarily a part of the record. Now, where that redefines what is meant by before the court is that at a hearing, a judge's possession of a document doesn't make it before the court. Where the prosecution has an evidentiary burden, the documents that are before the court are the documents that the prosecution has chosen to present to the court in support of their position, as they are required to do under Correction Law 168N. If the prosecution is correct, then their evidentiary burden under the statute and their due process requirements as codified in that statute are completely null. They have no obligation, and they can cherry pick whatever evidence they want on appeal that best supports their argument against what the appellant is making. It also conflates a criminal proceeding with an entirely distinct civil SORA proceeding, which has its own record on appeal, and by doing so, they create a continuous record on appeal. They conflate their prosecutorial role with the neutral arbiter role of the court. In their brief, they accuse us of making an accusation that we have accused the court of judicial incompetence by not reviewing the file. In fact, if the court is not permitted to present evidence of its own supporting sua sponte assessment of points, So they've conflated that issue. I suppose if the court doesn't have any questions, I'll reserve my time for rebuttal. Thank you.
You may proceed.
Thank you. Good afternoon, and may it please the court. Paul Anderson for the people. So I think my opponent overstates the concession we have here, and that was, did we prove the exact birth date by clear and convincing evidence? We weren't required to go into that much detail. We had to prove that the offense was committed against her under the age of 10. And so case summary, reliable hearsay, says she was 8 years old. That case summary reference to the PSR, also reliable hearsay. And then we give Justice Fabrizio the grand jury testimony of the complainant from her own words, describing a course of conduct occurring in 2006, and then describing her being 13 in 2011, 5 years later. 13 minus 5 is 8, or at least, very least, clear and convincing of under 10 years old. So I think counsel's conflating a lot of the arguments with moving to strike, our opposition to moving to strike the record, rather than what we relied on the hearing and what we're relying upon here on appeal. And so here, based on all that evidence in front of Justice Fabrizio, and he goes into, well, yeah, I don't have the birth date, but I have this course of conduct describing her age, and that is enough to meet our burden here. And so same thing in regards to the substance abuse. His statements to the probation, that constituted reliable hearsay. That was fair for us to use. And just to take a step back, even if we're wrong on the points here, it's academic because he would still be presumptively level 2, and there's nothing here that says that the risk was overstated, warranting downward departure. And so if your honors have no questions, I ask that you affirm. Thank you.
Thank you. You have 1 minute.
I'll only note a couple things quickly. The date of a birth is a pretty critical piece of information to establish how old somebody is. Despite the reference to dates in the grand jury minutes, there was
But
no...
counsel, we just heard from counsel, so why isn't that enough? The case summary, indicated it happened when he was 8 years old. The PSR, 8 years old. We have the court statement about the victim's testimony, 8 years old. Why isn't that enough?
The Court of
The
Appeals
assessment of the 30 points. Why isn't that enough? Clear and convincing evidence.
Certainly. When the Court of Appeals held that a case summary is reliable hearsay, they also noted that it's not automatically reliable, that the information contained in those statements can be questioned if there is other information that would raise those questions. The case summary and the PSR are relying on records that contain unproven allegations, and I think
her testimony?
Her testimony doesn't include a statement that she was 8. What I think is significant is to know
But it did say that, did talk about statements of when she was 11, and she referred, no?
13. The DA makes a statement that when introducing a question that after you had turned 13. There's no implication that is, there's an assumption that that's proximate, but there's no clear without the date of birth indication that she is 13 at the time that question is asked. So I don't think that you necessarily need to assume that she's 13 at that moment, which is what the prosecution needs in order to be able to do their subtraction. There's no clear indication of her date of birth and her age at the beginning of the time. Just quickly to note that all of those unproven allegations, I think, should be read in light of the fact that he was not indicted for anything containing an element under age 8. Thank you for your time.
Thank you.
Thank you.
Thank you.